this point, the court will also ensure that the parents understand the significance of ASFA, or the Adoption and Safe Families Act. This is a federal law that lays out the time frame under which the division will legally need to make a move to terminate the parents' rights. Essentially, the court is letting the parents know that the clock is ticking for them to do what they need to do to get their children back. That time frame is if the children have been in care for 15 of the last 22 months. The division then legally needs to move to terminate those parents' rights. This is a very complicated situation, so they do want to make sure that the parents know that the clock is already ticking as soon as the children have been removed. On the return of the order to show cause, the court will also look to the allegations and whether or not a fact-finding hearing or a trial will be needed, or if the parents will stipulate to the allegations against them. Essentially, the court either needs to make a finding of abuse and neglect following the trial, or the parents need to stipulate or admit to the allegations. One of these two, the finding or stipulation, will need to happen so that the court can continue to have jurisdiction of the matter. If a hearing is going to be necessary, it will be scheduled on this date as well as the next date for case managing. Essentially, a court date to stay on top of what's going on in the case and to make sure the kids are getting what they need. The court date that comes between the order to show cause and the fact-finding hearing, if there is a fact-finding hearing, are called case management conferences. At these hearings, the court looks at the progress of the case and what is going to be needed for the case to keep moving forward. The court may adjust whether or not different evaluations may be needed, such as psychological evaluations of parents or children, what services are needed by the children, and whether or not visits are happening and how they are going. If there is going to be a fact-finding hearing, the court will also look at the time frames for discovery, something we as CASAs don't need to worry about as we are not participant in the trial. Finally, before the case is adjourned, the next court date will be scheduled. The fact-finding hearing, if there is one, is supposed to take place within 4 months of the initial filing of the case if the child was removed from home, or within 6 months if the child is still home. Sometimes hearing will take place over several days if a lot of evidence is being presented. Strategically, there are reasons why the parents may or may not want the child. The parent may generally feel they may win the case and have it dismissed, or they may want to make a stipulation as it may move the case faster and also create favor with the judge. There are also considerations if there is a parallel criminal case going on. Strategically, there may be reasons why they may or may not want to have the fact-finding hearing. CASAs do not participate in the fact-finding trial, but we may observe it if we wish. We are not active participants. You do not have to write a court report or participate anyway in the fact-finding trial. At the end of the fact-finding hearing, the court will enter a fact-finding order where it will lay out the findings the judge made as a result of the trial. Essentially, what allegations the judge determined to be true. If there was a stipulation, there will be a stipulation order laying out what it is that the parents stipulated to. After the fact-finding/stipulation, the court enters a disposition order. The disposition order addresses services for defendant and child. This is significant in happening after the fact-finding and stipulation because now the court has jurisdiction to compel the parents to accept services. After disposition, the case will be in court approximately every 3 months for compliance reviews. These are held to inform the court of progress made towards meeting the service plan goals of the case. After each compliant review, the court will enter an order on custody and services that include visitation and also the next court date. As a CASA at these hearings, as you will at all hearings, you will provide the court with a court report to update the judge that includes how the child is doing and make recommendations for anything the child needs. Up until now, we have been talking about FN cases. An FN case can close after the fact-finding hearing if the court determines there was no abuse and neglect. It could also close if the child has returned home and the court determined that the issues have been remediated and the child is now safe. It can also close if the case has been going on for an extended period of time and the division has now filed a new petition, such as a petition to terminate a parent's rights or a kinship legal guardian petition. When these petitions are filed, they close out an FN case because the case is moving and taking a new step in the march towards permanency. You'll notice this change when you get the court orders and the case docket number says FG instead of FN. Here at CASA, we want our kids in safe, permanent homes as soon as possible. The court works in its own time frame. Every 12 months, a case is supposed to be scheduled for a permanency hearing. Up until that first permanency hearing, there is a presumption that the permanency plan for the child is reunification. Everyone should be working towards reuniting that family. All the services are being offered so that the family can be brought back together safely. However, that is not always possible in every case, and at the permanency hearing, the division proposes a permanency plan, and the parties have opportunities to tell the judges why or why not they agree with that permanency plan. That permanency plan may still be for reunification, in which case the division will say how long they think they need to achieve reunification. The division may also propose other permanency plans like adoption or kinship legal guardianship. They may also have different plans for different children depending on the facts of the case. After hearing from everyone, the judge may disapprove or approve the permanency plan or may approve the plan for one child and not the other. If the judge does not approve the permanency plan, the case will be adjourned with a short adjourned date for the division to come back with a new plan. To be clear, at the permanency hearing, a permanency plan is made for the children, but it doesn't mean the case is over. It's just a plan so everyone knows what the division is working towards. It doesn't mean the case is over, permanency has not been achieved, and also doesn't have to be the permanent goal. Things can change on a case, and the permanency plan can reflect those changes. And maybe even change when the next permanency hearing is because the plan may need to be updated for whatever reason.